Good afternoon, everyone. I'm Stephanie Garces, owner of Garces Law Firm. Thank you for joining us for Pink Mike Legal Confessions. It's been a while, so I'm happy to see you guys today. I wanted to check in because we have a really interesting episode today to talk about how do I add my loved ones to my estate plan, particularly when it comes to the financial accounts. A lot of people have questions about this. A lot of this is very it seems really easy, but there's a lot of complex, layers to it, depending on who's in the accounts, who's not in the accounts, who is living, who is not. I get questions like that all the time. So thank you so much for joining us today. As you know, legacy planning in general doesn't just mean the transfer of assets. It also means the transfer of accounts. And when someone passes away, or perhaps they haven't passed away, they're just not doing well, you may consider whether or not they have an estate plan together and who's on the account so that people can have access to the accounts. Financial accounts have been established for quite a long time now. Every bank has their own rules, but some of the stuff isn't changed where the bank is very, very in tune with wanting to know who's the person asking you to do the changes, how do you do the changes. So that is what we're talking about today. So, like I mentioned before, I'm Stephanie Garces owner of Garces Law Firm, founding attorney of Garces Law Firm. We're in Arlington Heights, where we help parents secure their legacies and prepare for the unexpected. Now, one of the few things that I'm going to be covering today that goes hand in hand with estate planning, as I mentioned, is financial accounts. Why do we care about who's on the financial account? What does it actually mean? Well, when we discuss creating a will, most people think that it's just a document that just tells people what your wishes are. And that's the only thing that you need. But it's a lot more complex than that. And there is so many questions that people have just from asking, do I need a will? I always say this on Pink Mike Legal Confessions, but you should always consider a basic estate plan, even if you don't have a lot. Many people say, I don't have a lot. That doesn't matter. You certainly want to have someone in charge of your affairs in the event of your unexpected absence. So that is always important. Several steps have to be taken, though, to ensure that your family members don't have to deal with the red tape and really getting stuck in the minutia of dealing with probate and dealing with all these other layers that come after someone has passed, expectedly or unexpectedly. Whether someone has a plan really does matter for the outcome. Financial accounts, in particular, require planning in advance. They have several ways to add designated individuals to have access to those accounts, whether it's when you're living. Other times, people will add something in the trust, kind of identify who would be the person in charge of their account when they're not living. And so today we're going to cover those topics in various ways to address the concerns of those of you who really want to know, how do I designate a beneficiary? And in some cases, even give access to your accounts or to your assets because of perhaps your mental state, or perhaps your age, or perhaps whatever chapter you are in your life. So that's usually one of the things I always talk about. Now, before I start, just so you know, I always mention this, but estate planning, as with anything else in the law, is not a one size fit all. Not everything is crafted perfectly. You can't use it every single time for every single person. So just keep that in mind as we talk, because everyone's individuality and different wishes are not the same. So there's always going to be different ways to handle the estate plan. But we are giving advice today, just in the general sense. So let's get started. So one of the things I get questions about a lot is, when is a good time to start thinking about adding children and loved ones to an account? Well, typically it depends. You have to think about who your children are, who is of someone that you trust, if it's a family member. Do you add them to the account or do you not? I mean, these are questions that come up. Everyone's situation is different. There may be reasons why you would want to add somebody. Many times people will come to me and say, well, my son is on the account with me, or my daughter is on the account with me. And while you can certainly do that while you're living, it's not a bad thing. You do have to keep in mind that the person that you're choosing has access to your money. So make sure that the person that's there is someone that you trust. And this can actually lead to a lot of family drama sometimes if someone is chosen over another sibling. or perhaps it's a family member, not someone else that's directly in the family. So that question is really, it depends. You certainly want to think about it. If you potentially think that you may need access to those accounts, and maybe your health isn't well, that's a good time to start thinking about it. There's also something that we draft up usually as an estate plan called powers of attorney that allows someone to really have access to those accounts in the event they needed to do something like handle a transaction and you aren't able to make decisions for yourself. So there are different avenues of just adding someone to an account. In adding to the account, it just depends on the situation. We don't always highly recommend it depending on the family dynamic, and other times it does make sense. So it just depends on the situation. Now, there are different types of assets that come up in an estate plan. And so there's different types of accounts. Just to kind of give you an overview of what accounts those are, there's investment accounts. Investment accounts are ones that you actually use to put in the marketplace, for example, or perhaps if you have a financial advisor that you work with, they'll have accounts that are specifically designated for investing and trying to grow that money. I always say grow it while you sleep. So this is money that's working for you behind the scenes. That's considered an investment account. Perhaps there's also like retirement accounts. Retirement accounts are very different than investment accounts to an extent. For example, there's 401ks. Those are considered retirement accounts, and those are treated a little bit different than the checking account, in that they tend to pass through the estate, assuming that there is someone already named as a beneficiary. So those are considerably important, but you certainly want to check to see if you have someone in place in those accounts. And typically we do assess those on a case-by-case basis. So when we do a consultation with someone, we'll ask them about this information because we want to see if they have everything in place. We don't actually know until we see the documents. Some of the other accounts that exist in an estate plan is bank accounts, as you already know, the basic checking or the savings account. Sometimes people will even have different types of accounts for their business. If someone is a business owner, you might have a business account. So those are other types of plans that are accounted for in an estate plan. And when we talk about these things, like I said, we thoroughly review everything to make sure that we know how much is in there, whether or not it's being set up properly, and do we have beneficiaries in place. Does this person already have an existing estate plan, or do they need to tweak it to make sure that everything is going in a direction to avoid probate upon their death? And that's really where our expertise really comes through. So there's also different assets that are handled with regards to real estate. That's actually one of the assets of the many assets that we talk about. A lot of times when clients have consultations with us, they talk a lot about their accounts and their money in homes. And absolutely, real estate properties are worth a lot of money, and they definitely matter in your portfolio of assets. So I just like people to think about that big picture. There is a whole conversation to be had when it comes to the actual real estate property, but it really matters where it's at, what states. Those are things that we advise on. Who are the owners of those properties? We ask about that sort of thing. How much is the value of the home? Is it in your name? Is it in another family member's name? So all of that stuff matters. And these are just other assets that I'm mentioning on a list of many assets so that you understand what's being considered when. So it really just depends on what we're dealing with. But real estate is really, it's tricky because there could be a number of real estate properties that one owns. I know personally, I've had a number of clients that have been fortunate enough to have more than one property. And so we certainly discuss what are your options when it comes to protecting those assets, other than just creating your trust. There is a level of protection to actually put a silo around those properties in the event something happens to you, or perhaps you want to leave it in your family or have them sell it. So there's a lot of things you could do with that. It's just important to talk about the real estate assets when it comes to an estate plan, because there is no other way around that. So you have to actually account for that in an estate plan. So just something to keep in mind. So those are kind of the big pictures of some of the assets. Of course, there's boats and cars and definitely people that have houses and cars that are worth a lot of money, those are still worth something. So those are things to think about. Some other assets could also be, I know I've had people have, Bitcoin. Bitcoin is a big thing right now that talks about, this talks about Bitcoin covers like the currency that talks about the electronic future of some of this currency. And, fortunately, that is something that is being explored and has to be considered during an estate plan. So if you're one of those Bitcoin users, you now know that could be considered an asset. The other thing is designated beneficiaries in general. That is really a process that each financial institution has. Certainly, there's a department for every bank where you can actually call, whether it's customer service or perhaps you can even go in if you'd like to go into the bank to sign the paperwork to actually add the beneficiaries to these accounts. And I cannot stress how important it is to even consider this as a step just in general. Even before you come see us or when you come see us, it's important for you to understand what are the accounts that I have, how many, what banks are they at. I know people will have more than one account sometimes, different banks and all of that. So just important for you to consider this because having a beneficiary in these accounts is vital. It's vital because you're really dealing with the potential of having a property, or should I say an asset that potentially doesn't have a beneficiary. So that really complicates things when, and actually even if it's in your name individually. I know people will have a spouse or significant other and they have things individually. That does matter, whether it's something that you can add a beneficiary, depending on the type of account. I know certain banks will treat certain accounts as ones that you can't add a beneficiary. So then you may have to convert it to another account. So these are just interesting points to discuss because, it's easy to say I'm just going to add somebody, but you really have to think about where are these accounts located? What kind of accounts are they? And can I add a beneficiary and how? As I mentioned, the customer service at every bank or even going in, these are forms that they give you. Some of them are called transfer on death. Some of them are called beneficiary forms. Just depends on the bank. Every bank is really different depending on the state where you're at and all of that. So those are things to think about when adding beneficiaries to your designated accounts to make sure those are in order. So we certainly got our clients in that, by the way, because it's very, very cumbersome to do that. So we certainly use that as a point to make sure we're giving the proper advice to make sure that clients are taken care of so that they can understand that we are here to help them till the end. So that's what that is. Now, one of the questions I also get once in a while is, how does a durable power of attorney work? Well, people will say, can it be used for accounts for someone to have access and spend the money without, my knowledge? Well, there are perimeters to these powers of attorney. The powers of attorney I always say, are very powerful documents. They're actually used when you are living, but cannot make decisions on your behalf. Typically, the power of attorney will have different stipulations in it. One of the ones that I'll say is, when do you want it to be active? Do you want it to be active now? Or perhaps when a physician were to deem you incapacitated. So there are parameters and everything is to an extent customizable in the power of attorney. Now there are specific ones that Illinois uses. So if you are looking to do this, you certainly want to get someone that is licensed in Illinois, particularly if you are residing in Illinois or in whatever state that you're in. I have clients that are between two states and they're snowbirds. So you certainly want to make sure you consult your attorney with that to make sure you're indicating to them where you are in different parts of the year, at least for residence purposes. But yes, the power of attorney does actually allow someone to have access to your accounts with parameters. Typically, you want not really without your knowledge. You would hope if you pick the right person, that won't happen. And also there's parameters to these powers of attorney. So you should not worry that someone's going to just go to the bank and steal your money. The idea is that you actually use this power of attorney. We craft it for you. We really consider and weigh the option as to who you would pick and who would be the right person for you. And then we actually put it together so that in the event you became incapacitated for some reason, then we can have somebody step into your shoes and have access to the accounts to do certain things. For example, if there needed to be a stock purchase or a stock sold, they would allow them to do that. To maybe enter into a real estate transaction. That would allow them to do that. There's a number of things. There's actually a litany of items that you can and cannot um, allow the agent or the person in stepping into your shoes to do. So you have full control over that. That's why the powers of attorney are very important in that it gives you back the control while you are living, while you are saying, so that you can actually make sure that everything that you want is in those letters. So that is just kind of a way that the durable power of attorney works. And it does allow for certain parameters as to what you will and will not permit that person to do. So hopefully not without your knowledge, because you would have come and see me and we would have put that together. But the idea is that they are very, very powerful and actually really, really important to really in any estate plan. Now, when it comes to protections so that money is not spent frivolously between like having a minor child or even young adult children, there are ways to customize your estate plan. And this is one of the things I like to do a lot, depending on the client and what their goals are. You can set a age, for example, for your minor children, or perhaps even young adult children, or any of your children for that matter, whatever age they are, to actually have access to some of the money or part of the estate that you left them. This is one of the reasons why getting an estate plan is so important, because there is no other way to do that. Many clients will say, I left my wishes with my daughter. She knows what I want. But unfortunately, the law in Illinois, at least in general, the law says you have to have this in writing. It has to be a valid estate plan, and it has to actually stipulate as to what you want. The great thing about working with us is that we do go thoroughly through your options. We make sure that you are happy with the final product in what it is that you want. If you have a change of heart, many people do. Someone will tell me what they want when we start, and then when we get to the end, they want something different. We accommodate those changes within reason, assuming that it's something that you would want and something that we're sure of. So we do counsel you through some of those parameters where it comes to age. I've even had people say, I only want to give my child X amount of money if they take a drug test or something like that. So there are different parameters, and you can be very creative. That's just one example of stuff we can do. So it's just something to keep in mind. You can imagine what a young adult would do with $500,000 if they were inherited at age 18, or younger than that. It really is. I don't have to tell you guys this, but it is kind of risky. So there is ways to put parameters around that. And that actually should be a reason for you to even want to put an estate plan together. So that's typically what that looks like. Now, I just want to recap for some of the people that are watching now. As I mentioned, today we are talking about how to add your loved ones to financial accounts. What does estate assets look like? And what are things that we really should consider when it comes to putting an estate plan together? I'm Stephanie Garces, owner of Garces Law Firm, where we help parents secure their legacy, as I always say. And we make sure that you are informed with these Facebook messages that I'm putting out here, because it's really important. Pink Mike Legal Confessions really, really helps educate some of the viewers so that you understand what is an estate plan, why do I need to care, and what does my legacy look like if I don't have one, and if I do have one. So that's something that we're talking about today. Now, if you missed my last episode, you can watch it anytime on my Facebook page. You can also watch it on my YouTube channel at Garces Law. We have our all our videos there for your access, so you can watch it at your convenience. And really, these are just short videos to answer most of the common questions we get when it comes to estate planning. They're quick, easy to watch. You can watch them anytime you want. We welcome you here on Tuesdays at 1 o'clock to discuss Pink Legal Confession topics that are relevant to you and anyone watching. Now, I know a couple people have questions about some of the stuff I've talked about. So I kind of wanted to go through just a list of questions that I've commonly received. If you have any comments that are currently on your mind and you want to share in the questions box, go ahead and feel free to drop it in this Facebook Live, and I'll address it as quickly as I can during our Facebook message. Now, when we're talking about estate planning, one of the things that comes up a lot is people will ask, who other than family members can control an estate or perhaps a business? And This is really important to discuss because when it comes to family members, of course, and you can name any family member to really control your assets when it comes to your business or your estate. However, there are other ways that you can actually have someone really just be in charge of your affairs and really oversee everything. There's something called a corporate fiduciary, which is a bank, for example, can sometimes be named as the person that's going to be in charge of the estate. They're kind of the gatekeepers of that. Sometimes that's a good option depending on the person and what their situation is. Outside of family members, which is the one that most commonly people ask for, there is this idea of having a corporate fiduciary, which is a corporate entity like a bank, typically a financial institution that handles the estate and the administration of it. Assuming that the estate plan is put in place, there isn't any reason to go to probate in that extent. But there is a third party that's involved. So that is something that you can do for your estate plan that can also be an alternative to family members or loved ones being in control of your assets. So again, depending on your family dynamic and what you see for your legacy, that is something that we also discuss if that is suitable for your position. Now, another question I get every so often is how do I remove past spouses or partners on accounts, especially financial accounts? And this is a really great question because it comes up a lot. When I had mentioned earlier about customer service lines and the bank, you really want to reach out to your bank as soon as possible. This is something you do not want to wait for because you just want to make sure that the beneficiaries or the person on the account that has authority the same way you do is someone that you are comfortable with. So if an ex-spouse or ex-partner is on there and you wish to remove them, just contact your bank as soon as possible and indicate to them that there is a process that you want to start to remove who is on, who is off the account. And they do walk you through that. But one thing's for sure is you don't want to wait, because if you wait and something happens to you, it would be null and void. So you certainly want to move forward on those if you're thinking of doing that. Someone had just asked a question is, can my lawyer serve as a trustee or power of attorney? Typically, the general answer is yes. However, not every attorney does. So it really is case specific and law firm specific. So depending on the client and depending the circumstances, you could always have your attorney do that, but not every attorney or law firm does, for purposes of just liability and perhaps even maybe potential if it's any conflict of interest or some other idea or other reason there could be. So it really just depends. It is possible, but it just depends on who you're doing your estate plan with and the circumstances. Now, in general, one of the most common questions we receive is, how much does an estate plan cost? Well, the short answer to this is it depends. You knew that was coming. But when it comes to the estate plan in general, it really, really ranges. And the reason is because everyone's case is different. At the start of this Pink My Little Confessions, I mentioned to you that this is not a one size fits all. So if you are somebody that perhaps doesn't need a super complex estate plan, something very, very basic, on the lower end, the minimum you would spend possibly could be $400. Let's just say that's usually a starting point for just a basic estate plan. That could be a will, maybe some powers of attorney. That would be a little bit more than 400. So it just depends on what we're adding. If we go the trust route, really depending on the assets, it's how we gauge the price. And that's why it's hard to quote, because sometimes people will say, oh, I don't have much. But then once you start looking at all the assets, it turns out it's a lot more to protect than we thought. So that could range. It could range anywhere from $2,000 to $4,500. I've seen estates also go for like the bigger net worth clients go up to like $6,000 or $7,000. It really depends, because we want to make sure that the assets that you're setting forth are protected. And so I don't want to give you a quote without really understanding the assets. So it is something that you'd have to come see us to really properly quote you and to kind of give you an idea of how much it would actually cost at the end of the day. So the question is a good one, but the answer is it depends depending on the person. So it is a case by case basis. And as far as the appointments that I offer currently, because of the pandemic and really because of the world that we're in, we offer in person, we offer virtual meaning, Google Meets or Zoom or Teams, if whatever platform you're comfortable with. I know Google Meets it's actually very simple for us to use. We do offer virtual appointments in English and in Spanish, just so you know. So consultations are free, 30 minutes, and we do offer that to any client that is interested. You can always call us at 773-373-9592, text or call that line to make an appointment for your virtual consultation. If you are comfortable coming in person, you can certainly come on site. That's not a problem. We will accommodate you. So that is really the spiel today. I don't know if I have anything else to share, but I think we covered a lot today. So I just want to thank all the viewers for watching and really just joining us every season that we do this. I know we're going into the different season. We're going into winter, but I do want to thank you guys for watching. I really appreciate the feedback, the support that we get. And quite frankly, it's fun to learn about what people want to know about and be able to share my platform with you so that you know more than when you started. So feel free to always reach out to us. We can help you with your estate planning, real estate, or civil needs. And don't ever hesitate to give us a call. So as I always mention, I cherish the opportunity to work with you and your families if you choose to do so. And really, really just want to thank you again. So feel free to join us on Tuesdays, 1 o'clock, and we'll be covering a new topic shortly. So thanks so much for joining Pink My Legal Confessions, and I hope you all stay well. Take care.